The adjuster assigned to your friend's homeowner's policy knows something that you don't. When you walked into that house as a guest, Maryland law classified you differently than if you'd walked into a store. That classification difference is important to the value of your case. Kevin went to his friend Tom's birthday party, walked out the side door onto the back deck, stepped on a board that had been loose for months, and went down hard. Broken wrist, torn knee ligament. Tom drove him to the hospital. Kevin said, "Don't worry about it." 3 weeks later, Tom replaced the board. Hi, I'm Bobby Zirkin with Zirkin Schmerling Injury Lawyers. If you were hurt at a friend's home in Maryland, what you don't understand about how the law classifies you, either as a social guest or business invitee or what have you, may be the reason you never recover a dime. The best evidence in Kevin's case disappeared because his friend eventually did the right thing. The legal status that changes everything. The adjusters already made the classification. You didn't even know that there was one. When you walk into a store in Maryland, the law classifies you as a business invitee. The store must use reasonable and ordinary care to keep the premises safe and protect you from unreasonable risks, even ones you wouldn't notice on your own. They have to inspect, they have to fix, they have to warn. When you walk into a friend's house, you're classified as a social guest, and the duty that your friend owes is different. They have to warn you, for example, about known dangerous conditions that you wouldn't easily discover on your own. But they don't have to actively inspect the property for hazards the way that a business does. The difference between keep the premises safe and warn about known dangers is pretty big. One requires property owners to go looking for problems and ensure safety. The other only requires them to tell you about problems that they already know exist. The insurance adjuster's first move in your case is confirming what kind of a guest you were, or what kind of an invitee you were. That classification changes everything from the legal standpoint. What to understand. As a social guest in Maryland, you are owed different legal protections than a customer at a store. The question isn't whether the hazard existed, it's whether your friend knew about it, what your friend knew and how to prove it. The adjuster wants this to be a "we had no idea" case. Your job is to prove it was a "they walked past it every day" case. Because you're a social guest, the central question in your claim is whether the homeowner knew or should have known about the dangerous condition that hurt you. If they knew and didn't warn you, they may have breached the duty they owed you. If they didn't know, the insurance company will argue there was nothing to warn you about. Here's where that argument falls apart. Knowledge doesn't require a written maintenance report. It doesn't require a formal complaint. A loose board your friend stepped over every time they walked onto the deck, that's knowledge. An icy walkway they didn't salt after watching the storm from their window, that's knowledge. A broken step they mentioned to a contractor 6 months ago but never repaired, that's knowledge. The proof comes from how long the condition existed, whether the homeowner used the same area regularly, whether other guests or family members noticed it, and whether any steps toward repair were discussed or even started. Your friend's daily use of that same deck, that same stairway, that same walkway is evidence that they knew or should have known. What to establish? How long the hazard existed, whether the homeowner used the same area, and whether anyone else noticed or mentioned the condition before you were hurt. The evidence problem nobody warns you about. Every day that passes without documentation is a day that the adjuster wins. 3 weeks after Kevin's accident, Tom replaced the board on the deck. He wasn't destroying evidence, he was being a responsible homeowner. But the result is the same. The physical proof of the dangerous condition that caused Kevin's injuries in the first place is gone. This is why injury cases at a friend's house are harder than a slip and fall at a store to some extent. At a store, the hazard might get mopped up in minutes, but there's usually surveillance footage. There's an incident report. There's a manager who documented what happened. At a friend's house, there's no camera usually. There's no report. There's no record of the condition. The only evidence that will ever exist is what you create yourself. Photograph the hazard before your friend fixes it, before the ice melts. Photograph the scene, the lighting condition, the area around the hazard. Photograph your injuries that day and every day after as they develop. Get the names of anyone who was at the gathering, saw the condition, or the fall. Write your own detailed account while the details are still fresh. The time, what happened, what you saw, what was said. If you wait, your friend will fix the problem because that's what good homeowners do. And the best evidence in your case will disappear because of it. What to preserve: photos of the hazard before it's repaired, your own written account of the incident, names of anyone who saw the condition or the accident itself, and photographs of your injuries every day as they develop. Maryland's contributory negligence rule and how it's used in a case like this. At a friend's party, you're a relaxed guest. The adjuster likes that scenario a lot more. Maryland follows contributory negligence. If the insurance company can argue you were even 1% at fault for your injury, they can use that to try to bar your entire claim. I covered this in detail in our dog bite video. The rule is exactly the same, but here's why it's even more dangerous in a friend's house. At a store, you're a sober customer walking down an aisle. At a friend's birthday party, you're relaxed. You may have had a drink or two. You're not inspecting the property for hazards. You're not watching every step. Every one of those normal party behaviors becomes ammunition for an adjuster. Were you wearing appropriate footwear? Had you been drinking? Did you see the condition of the deck before you walked out onto it? Were you looking at your phone? The adjuster doesn't need to prove you were mostly responsible. They only need to prove that you were just a little responsible, and that bars your claim because of contributory negligence. And a party gives them more material to work with than a grocery store aisle ever would. What to protect: do not describe the party atmosphere, your alcohol consumption, or your footwear to any insurance adjuster without talking to an attorney first. Do not talk to insurance. It's the insurance company, not your friend. You already know this if you watched our video on dog bite claims. The same principle applies here. Your friend has homeowners insurance or a renter's policy. That policy covers liability for injuries that happen on their property. You're filing a claim against the policy, not against the person. Your friend doesn't write the check. The adjuster handles the process. The policy pays. If your friend rents, their renter's insurance may cover the claim. And in some situations, the landlord may also bear responsibility if they failed to maintain the property. An attorney can identify every available policy. The insurance company is counting on you being too polite to file. That politeness is their profit margin. So what to find out? Does your friend own or rent? What insurance covers the policy? Your attorney needs this answer immediately. So what to do right now? The evidence window is days. The statute of limitations is years. The evidence won't wait for you. Get medical care immediately. Let the record speak for itself. Describe exactly what hurts, where, and how much. Don't minimize because you don't want to make your friend feel worse. Photograph the hazard before it's repaired. This is the single most important thing you can do for your case. Once your friend fixes the condition, that evidence is gone permanently. Get the names and contact information of anyone who was present, even if they're mutual friends, even if it's a little awkward. Witnesses matter, especially witnesses who saw the hazard before you fell. Write your own account of what happened while the details are fresh. Time, location, what caused the fall, what you said, what was sent to you. Do not make any informal agreements with your friend about covering the medical bills or figuring something out. Do not give a recorded statement to any insurance company without talking to an attorney first. In Maryland, you have 3 years from the date of your injury under CJP Section 5-101, but the deck board won't last 3 years. The ICE won't last for 3 years. The evidence lives on a different clock than the lawsuit. What to demand: photos of the hazard before it's repaired, your complete medical records, and a conversation with an attorney before you talk to anyone's insurance company. The biggest mistake after an injury at a friend's house is being kind at the expense of being protected. Your friend will fix the hazard, the evidence will disappear, and the insurance company will treat the whole thing like it never happened. If the injury involved a dog bite instead of a fall, watch our video on how to file a dog bite claim against a friend in Maryland. Different law, same insurance system. If you were injured at a friend's house in Maryland, call Zirkin Schmerling Injury Lawyers. The consultation is free. I'm Bobby Zirkin, and I don't let politeness cost my clients what they are owed.